What is the likelihood that same-sex marriage will be banned? What is the likelihood that Obergefell versus Hodges will be overturned? So I've been thinking about this question deeply, and I've done as much research as possible to figure out whether it's likely that same-sex marriage could be banned in certain states. The reality is that it is possible, but please allow me to tell you about all the research that I've been doing on this topic. So right here, we do have our main bad guy here. He is my arch nemesis, Clarence Thomas, but I'm going to get back to him later because I need to tell you about what I have been seeing on Twitter, which kind of sparked me, kind of caused me to even do this research and try to figure out the answer to this question. So first of all, we have Representative Josh Shriver, who works in the House, who basically said flat out, make gay marriage illegal again. This is not remotely controversial nor extreme. He's got 7 million views on that tweet. I actually want to go over to this other person behind him because what he says is a little bit more substantive. He said a lot. It's Myron Gaines from the Fresh and Fit podcast. When I click on his name, okay, yeah, he's Myron Gaines from the Fresh and Fit podcast. I was having an issue where sometimes when I click the name, it would say that I think he basically deleted his account, but he basically said a whole lot more. He said, gay pride needs to be reverted back to gay shame. It's not a flex to be a homosexual, lesbian, or one of the 96 genders they claim exist. If you want to be a deviant, you will be afforded human rights and liberties. All right, I'm going to tell you that's already not right if your point is exactly what you're about to make next, but okay. However, there are consequences and you will not be afforded two privileges. There's the problem. You're trying to say you'll be afforded rights and liberties and you take it away in the next sentences. He says that you will not have the ability to marry and you will not have the ability to adopt children. Marriage is a religious ceremony. None of the major world religions allow homosexuality. Allowing gay marriage is a blatant disrespect to said religions. Homosexuals have civil unions recognized by the state, but marriage is between man and woman only. So he's mincing words here. He's trying to make it he's trying to say, oh, it's a religious thing. While also saying that it's between a man and woman only. Raising children is a sacred privilege afforded to nuclear families only. Man and women, not sexual deviants, cannot properly raise the children. So he said a lot more. And so, Myron Gaines, I actually liked that Fresh and Fit podcast until I saw this. This is quite terrible. So going back to Representative Josh Shriver, guy who works in the House, he recently put this tweet out. I'll be introducing a resolution like this in a few weeks to help restore traditional marriage. So Idaho has written something. I'm just going to read the resolution. There's an important sentence right here. It says, be it further resolved, calls upon the Supreme Court of the United States to reverse Obergefell and restore the natural definition of marriage, a union of one man and one woman. So this document is going to be really problematic, and I'm actually going to come back to it. And I'm going to go back to Clarence Thomas, the Supreme Court. But actually, Clarence Thomas is not the initial villain here. Something else, another Supreme Court justice is actually the catalyst, even though we're going to find out that he's not necessarily against same-sex marriage in the beginning. He is a catalyst because Mr. Alito is the leader of the opinion that overturned Roe versus Wade. So we have to go back to Roe versus Wade here on CNN. We're going to break down Samuel Alito's opinion that struck down Roe versus Wade. And so when he overturned Roe, he said, Roe must be overruled. Alito began where critics of Roe always begin. The Constitution makes no reference to abortion. So he believed that Roe needed to be overturned because the Constitution itself does not say anything about abortion. So this is called originalism. Okay. He also added, in fact, according to Alito, Roe was egregiously wrong from the start and his reasoning is exceptionally weak. Alito concluded that it's time the issue went back to the states. That is what the Constitution and the rule of law demand. So you're going to hear a lot about states' rights. So I want to clarify something about Alito, though, is that when he talks about states' rights, he also said this. He also distinguished Roe from past decision involving matters such as sexual relationships, contraception, and marriage. Really important because Alito is saying that, okay, Roe versus Wade needs to be overturned, but that has nothing to do with um, sexual relations between gay people, contraception, and gay marriage. So in a way, Alito is saying that he supports gay marriage, even though he used and I'm going to go back here. The fact that the Constitution makes no reference to abortion, he used that as the reason to overturn Roe, but he says that does not apply to gay marriage. So, yes, he said that, but guess what happened? Mr. Clarence Thomas agreed with the part. I'm sorry, Mr. Clarence Thomas agreed with overturning Roe, and then he had to add some other stuff. And this is CNBC. What's the headline? Supreme Court Clarence Thomas says gay rights contraception should be reconsidered after Roe was overturned. It's so fascinating because I get that Alito said that this should not apply to gay marriage. But of course, somebody else in the court comes around and says, actually, you know what? I think gay marriage should be overturned. And so I'll read a couple of points. Supreme Court Justice Clarence Thomas said landmark high court rulings that establish gay rights and contraception rights should be considered now that the federal right to abortion has been revoked. So it's always funny. Like I said, going back to Alito, he said, this does not apply to gay marriage. No, no, no. And then Clarence Thomas says, because you overturned Roe, this can apply to gay marriage. Great. Thomas wrote that those rulings were demonstrably erroneous decisions. The cases he cited were Griswold versus Connecticut, in which the Supreme Court said marriage couples have the right to obtain contraceptives. So really awkward here. We have to understand that Clarence Thomas is very religious, but he might have, I'm going to change that sentence, he might have a desire to ban condoms. Yeah, I'm serious. No, I'm serious. I'm not being ridiculous. He says it right here. He says the cases he cited are Griswold versus Connecticut, in which the Supreme Court had something to say about condoms. So he's probably going to overturn condoms. I'm sorry. Sometimes this stuff is like a TV show. I don't mean to laugh about this serious thing. In Lawrence versus Texas, which established the right to privacy in gay sex. The right to privacy means, hey, stay out of my bedroom. What we're doing is inside this bedroom is between me and the other guy. Like, stay out of there. In Obergefell versus Hodges, which is, did I say Hedges? Obergefell versus Hodges, which said there's a right to same-sex marriage. So I'm going to come back down to what he said. The case he mentioned are Griswold versus Connecticut, the 1965 ruling in which the Supreme Court said marriage couples have the right to use condoms or to buy condoms. Okay. Lawrence versus Texas, which is about making it illegal for gay men to have sex, point blank, period. And of course, he wants to get rid of the 2015 ruling of Obergefell versus Hodges, right? Let's read a little bit about let's read a little bit of what he said. The court well explains why, under our substantive due process precedents, I'm going to get back to substantive due process. That's really important. That purported right to abortion is not a form of liberty protected by the Due Process Clause of the U.S. Constitution's 14th Amendment. That clause guarantees that no state shall deprive any person of life, liberty, or process without due process of law. Super important. And it's going to be weird how he tries to challenge this part because you really can't, but he's going to try. Thomas argued that the right to abortion under that clause is neither deeply rooted in his nation's history and tradition. And then he said the three cases he's going to reconsider. I read that wrong. But he specifically said they are based on the idea of substantive due process. I can't say that word, which in a prior case he called an oxymoron that lacks any basis in the Constitution. You're going to hear the word due process a lot. Substantive due process. 14th Amendment is going to be the most important thing. Okay. And so what I want to do is talk about the story of Obergefell. This man is the most important man in this case. Um, so what happened with Obergefell is that he wanted to marry his husband, right? And so his husband, who unfortunately did pass away, his husband was, oh my God, his husband was sick. And so the reality is that if his husband were to pass away, basically he would not be afforded any of the rights of a married person. Like normally with same-sex couples, if a spouse passes away, there's a lot of benefits that the surviving spouse receives, and he was not going to receive any of those benefits if his husband passed away. So what he did is he traveled out of state. So he lived in Ohio, and I feel like Gen Z might make a meme about this being in Ohio. He lived in Ohio. He left Ohio. He went to another state, got married, came back to Ohio, and Ohio basically said, "We don't care that you got married in another state. We don't care. Doesn't matter to us. We don't recognize that you were married." Okay, so like it says right here, two individuals, James Obergefell, his name is always hard to pronounce, and John Arthur James filed a lawsuit challenging the state's refusal to recognize same-sex marriages um, on death certificates. The two were legally married in Maryland, right? Mr. Arthur, who suffered from a terminal illness, died several months after litigation began due to Ohio law. Under both the Ohio Constitution and the Ohio Code, plaintiffs believe that state officials would refuse to indicate Mr. Arthur was married at the time of death and that Mr. Obergefell was his spouse. I'm going to scroll down a little bit. On June 26, 2015, the United States Supreme Court ruled in a landmark decision that the 14th Amendment requires all states to license marriages between same-sex couples and to recognize all marriages that were lawfully performed out of state. So that is exactly what Clarence Thomas dislikes. He does not like that happened, and he wants to overrule that ruling that was already ruled on. So I want to go ahead and talk about something that's really important here. It's called substantive due process. I said that word, I can't pronounce the word. Substantive due process is a constitutional law that protects rights from government interference. It's based on the Fifth and 14th Amendment. 14th Amendment is the most important amendment here, which prohibits the government from depriving a person of life, liberty, or property without due process. So another way to look at the phrase due process is the court's jail, right? So, if you did a crime, obviously you go to court, and if the court finds you guilty, you go to jail. That's the only time that you can be deprived of that. Substantive due process ensures that laws are fair and just and that the government has a sufficient reason to take away a person's rights. Sufficient reason is only jail. That's it. For example, if a law unfairly restricts a person's personal freedom, substantive due process protects those freedoms from being violated. So a couple of examples of substantive due process is the right to work in a normal job, the right to marry, okay, obviously very important to my research here, the right to raise children, reproductive rights, which unfortunately that fell flat and we did lose Roe, LGBTQ rights, and end-of-life decisions. Okay, so I want to kind of simplify the concept of this phrase, substantive. What's wrong with my tongue? Substantive due process. Okay, what's really important to understand about substantive due process is that these laws always comes out from the rulings and the interpretations of the Supreme Court. It's not usually in the Constitution or any of your amendments. So it's always an interpretation of the Constitution. The Constitution won't say it, but the judges will interpret it. They'll say, well, I guess what it means here is that, for example, the right to marry is protected because of something called the Equals Rights Clause, which I'm going to get to uh, quite soon. So let's talk about the 14th Amendment, which is super important. And the 14th Amendment, um, it goes like follows. So we have citizenship. I'm going to make a separate video on citizenship because, boy, we have some stuff to talk about with that one. But all people born or naturalized in the United States are citizens of the United States in a state where they live. This includes formerly enslaved people, really important part. Okay, now I'm not going to get too deep into the citizenship because that's, we know we're debating immigrant status, legal immigrants. I'm going to get into that later. So, equal protection. No state can deny equal protection of the laws to anyone within its jurisdiction. Due process. No state can deprive a person of life, liberty, or property without due process. Remember, that's jail. That's you did a crime, so then you get due process protection. Privileges and immunities. No state can make or enforce laws that take away privileges or immunities of citizens. So let's go ahead and talk about why did the 14th Amendment even get created? The 14th Amendment had everything to do with slavery and the rights of Black people. Okay, that's what the 14th Amendment was really for. And so the equal protection part, why was that so important? Important is because Black people were only able to be afforded equal protection under the law. They were able to get the same rights as white people. Okay, that's really important about what equal protection means. It means that everybody deserves equal rights. Okay, we all have the same rights. Okay, that's really important. So when it comes to the Supreme Court ruling Obergefell versus Hodges, right? When it comes to that ruling, what the Supreme Court ruled is that gay people get equal protection, get equal rights, get the same equal rights that straight people get. Straight people can marry, so gay people can marry. It's really that simple. If heterosexual people can get married, gay people can get married too. It's funny because when you say it in such a simple sentence like that, it makes sense, and yet it still gets debated. It's really unfortunate. So the debate always seems to fall down to something like this. The 10th Amendment. So the 10th Amendment is the states' rights amendment. I don't know if you ever heard people say states' rights, states' rights, states' rights, states' rights. What are they complaining about? What are they talking about? So I want to go ahead and read the 10th Amendment. The 10th Amendment to the United States Constitution states that any powers not given to the federal government are reserved to the states or to the people. So going back to Obergefell versus Hedges, this issue was left to the states. One state could say, "Yeah, gay marriage is fine," and the next state would say, "No, it's not." So Obergefell versus Hedges made it the law of the land, the law of the entire United States. Any part of the United States, any state that you go to, must allow same-sex marriages and must recognize same-sex marriages from other states. So what people who are against same-sex marriage will argue is that states have rights. Well, states' rights should supersede the federal government, right? So the reality, the simple question. Let's talk about that question, because the fact is, states' rights never ever supersedes the powers of the federal government. That issue has been settled throughout history. A long, long time ago, in the very beginning of America, we did the thing where the federal government was inferior to the states. And that quickly didn't work out. And we quickly fixed it so that the federal government has the final say, the final laws, okay, at all times on all matters of law, okay? But what they do also say is that whatever law the federal government does not make, right, the states have the power to make that law. So this was a fair situation or a valid situation before Obergefell versus Hodges, because I will admit that gay marriage or gay marriage is a newer situation throughout history. It hasn't been, well, actually, I wouldn't say it hasn't been allowed or in any way, shape, or form in the past, but it's kind of a newer situation that the Supreme Court had to deal with. And so what was going on is that the Supreme Court finally made the rule in Obergefell versus Hodges and said that same-sex marriage is the law of America, the entire United States of America. But can I use an example? So imagine this. Imagine you worked for a company, right? And you went to that company and the company said, in order to work at this company, you need to wear a black shirt and black pants, right? Um, that's our rule. So let's say you go to that job with a red shirt and black pants. You get fired. And then you go to another job, right? And at that job, they tell you, we don't have a dress code, right? You can wear whatever you want, right? So because that job did not create a dress code for the company, you have the right to wear whatever you want. So that's kind of an analogy for this. Now, going back to that first company, that company had that right to make that law. When they made a dress code policy, you had to follow that. In the second company, when they don't have a dress code policy, it's up to you. You have the right to wear whatever you want. It's your choice. It's your interpretation. You can wear whatever you want. So let me talk a little bit about Clarence Thomas again, because he is very enthusiastic about overturning Obergefell versus Hodges. We know that he is a religious man, and so his feelings about this are simple. He just thinks that the Bible says that it shouldn't. It just shouldn't. It just shouldn't. It doesn't need that. From his perspective, it's not that complicated. It really just shouldn't in his mind. So, what's going on with Clarence Thomas is that he solely wants to be the one to get this thing overturned. Okay, but there's something that's really important for you to understand is that it can't. He just can't say, okay, let's take another look at it. He has to wait for a case to come to the Supreme Court that he could actually rule on. Okay, that's just how it works. So we have to wait for something to uh, ch- to challenge same-sex marriage in some way, shape, or form, so that Clarence Thomas can get that opportunity to rule on it. So now, what's really important to understand too is that no state can truly, as of right now, no state can ban same-sex marriage. So just because, like, for example, just because Trump gets in office, none of the states can say, okay, now that Trump's in office, we now ban same-sex marriage, right? There must be a challenge of some kind. And so what the states can do, I want to come back to Twitter and come back to Representative Josh Shriver and what he's doing. And I want to come back to the document, right? So maybe I should read this document again. So be it further resolved that calls upon the Supreme Court of the United States to reverse Obergefell and restore the natural definition of marriage, a union of one man and one woman. So essentially, with this resolution, um, this is a challenge. So they're not going to particularly make same-sex marriage illegal. Like a state isn't going to really be able to do that, but they're going to bring a challenge like this. Okay, this is how they're going to do it. Another way that Josh Shriver or people who are against gay marriage could bring this. I'm sorry, not him, but another way that a challenge could arise is if a state chooses not to give tax benefits to a gay couple, a gay married couple, or an issue arises with gay adoption. Okay, going back to Mr. Myron Gaines from Fresh and Fit, he already, even though he's not a politician, he already pushed the point that gay people should not have the ability to adopt children, right? So that's what if that challenge, if a gay couple tries to adopt children and uh, the state or the city challenges that in any way, that case alone could rise to the Supreme Court and create a problem like that. And I wanted to talk about Philadelphia because something had began to happen in Philadelphia that actually created a problem. So in Philadelphia, I don't know if you know that in Philadelphia they have Catholics run the adoption agency. So this is you most likely going to be the thing that can cause the case to rise to the Supreme Court and create an issue. So Catholics are not okay with gay people adopting kids. And so if a gay couple comes in and says, I want to adopt a kid, and then, oh, I forgot it does say the Supreme Court sided with them. So somebody comes in and says, I want to adopt kids, and then that goes up to the Supreme Court. They can go ahead and come back around to Obergefell versus Hodges through that method, through that pathway, right? So that's one thing that could happen. So when it comes to, so when that case does arise to the Supreme Court, Mr. Clarence Thomas, my arch nemesis, this guy right here is going to, I want to say most likely he's going to take on that case. It's a possibility that he won't because Supreme Court John Roberts might not give it to him. But if they give it to him, yeah, he's with when it comes to him, he's just gonna say basically because he's an originalist, and he's going to say that the Constitution does not say anything about gay rights. I'm sorry, it doesn't say anything about gay marriage, so gay marriage cannot be a thing. Okay. Um, that's pretty much like it's unfortunate because I always think about when they take this stance, it's very weird. They pretend like they have no authority to make the laws because every time they interpret the law, they're essentially making a law. But he's going to say that because the Constitution never said anything about gay marriage, it can't exist, even though it was already interpreted in Obergefell versus Hodges, right? That's already been interpreted, so there you really can't go back on that. Okay, um, so I think that when it comes to the other Supreme Court justices that are there, I think it's going to be way more mixed than you'd expect. I don't really, outside of Clarence Thomas, Clarence Thomas is particularly the one person who is egregiously concerned about this. But I think the other justices are have mixed opinions. And I would not be surprised if there is a swing court justice who actually doesn't makes it possible for Obergefell to not be overturned. Of course, I don't have a crystal ball. I can't really predict these things. But I would actually argue that it's a little bit difficult to overturn it, even with Clarence Thomas being the one who wants to make that happen. So let me ask you. Let me just put it to you like this. So if the ruling isn't overturned, could it be overturned? And the reality is, yeah. Um, Even though right now I think it's more difficult, it's likely difficult for it to be overturned with the current justices. Trump just got elected. And my boy Trump, I can't believe I'm Googling a picture of Trump. Oh, perfect pictures too. Um, is going to nominate Republican Supreme Court justices and most likely Supreme Court justices who are against Obergefell versus Hodges, most likely. And if he were to do that, now we have a real problem because the opinions of the justices will be less mixed. We'll have somebody who's probably very strongly against gay marriage, and that's going to be a problem. That's going to be a problem. So let me be pessimistic because you got to be. Um, if it is overturned, if Obergefell versus Hodges is overturned, same-sex marriage would not be the law of the land. Very sad. I'm going to read this part. It says, if the court were to overturn Obergefell, the legality of same-sex marriages would revert to the state law. Right. It'll go back to what it was before. The states were making the laws about whether they recognize same-sex marriages. The majority of states would prohibit it. That's kind of the unfortunate reality. The majority of states do not support same-sex marriage. The Respect for Marriage Act wouldn't change that. I'm sorry, I forgot to explain what the Respect for Marriage Act is, but the Respect for Marriage Act basically, let's go down here. Okay. The Respect for Marriage Act basically says that every state must recognize gay marriage if that couple got married in another state. So if you live in a state like Ohio, I'm not sure if they'd ban it, but if Ohio banned it, yeah, okay, this is a good example. If Ohio banned gay marriage, you could go to New York, get married, and when you come back to Ohio, they must recognize that you got married in New York. That is what the Respect for Marriage Act is. Okay? And so I'm going to continue repeating or reading this article. The Respect for Marriage Act wouldn't respect it, but it requires all states to recognize same-sex marriage performed in other states and federally recognizes this marriage. The law unexpectedly gained Republican support. I'm going to tell you why. And passes the Senate after being amended to ensure that non-religious, nonprofit religious groups aren't required to perform same-sex marriages. So the reason that the Respect for Marriage Act exists is because the Democrats made a deal with the Republicans and said, okay, if there is a church that does not want to marry gay people, they are allowed not to marry gay people. I think that's totally fine. Why would you want to get married in a place that hates you? You know, so pretty interesting deal. It shows that sometimes you got to make deals that are a little bit sticky and hairy. But that made the Respect for Marriage Act go through. So that's what things would revert back to. Now, I'm going to tell you the truth. If Obergefell gets repealed, there will be a million lawsuits. Oh my God, there's going to be so many lawsuits on this because there's so many marriages that are already people who are already married. There's so many. So this case is going to eventually go back to the Supreme Court again and again, or go to the other courts. It's going to be a mess. It's going to be an annoying, constant mess because the rights were already afforded to gay folks. So let me ask you this question. So what can we do in the case, I told you the worst case scenario, in the case of more Republican Supreme Court justices getting nominated who oppose gay marriage getting nominated. So what can we do about that? It's really important that any Supreme Court justice elect, no, not elect because they're not elected, potential nomination, get asked a simple question. Do you support gay marriage? And so why it's important to reveal it is because I actually do believe that quite a bit of Republicans, even in the Senate, are not opposed to gay marriage. So the only defense that we have against Trump nominating, those kinds of Supreme Court justices is just revealing the truth, because there are so many Republican justices who don't feel like they need to ban the gay marriage at all. So, with that being said, I do want to say that I conclude that with the current Supreme Court justices, it's unlikely but not impossible for same-sex marriage to be banned. Um, we would have to see, and things are constantly changing. And so, like I said just a moment ago, if more Republican Supreme Court justices who oppose same-sex marriages are nominated, um, confirmed by the Senate, it is more likely, like very likely, that same-sex marriage would be banned. So, with that being said, I hope that this is helpful. And to be honest, I hope that same-sex marriage is not overturned. But the only thing we can do is wait and see. Thank you very much.